All right. Well, hi, ladies. Here is the rest of our lecture on civil rights. We already covered civil liberties in class, so I'm just going to go over civil rights today with you over a screencast. Okay. So, civil rights, just a reminder, are the government-protected rights of individuals against arbitrary or discriminatory treatment. The burden to protect these rights is placed on the government. We talked about the difference in freedom to or freedom of with civil liberties, and for the civil rights, it's actually freedom from. So it tends to be around freedom from discrimination is kind of the most common example. All right, so civil rights begins with the separate but equal doctrine that came about with Plessy v. Ferguson in 1896. This legalized racial segregation is constitutional as long as there are separate but equal facilities for blacks to use. Now, the court case was around railroad cars, but it also applied to things like buses, water fountains, hotels, restaurants, schools, etc. The big thing you need to know is that it was overturned in Brown v. Board of Education in 1954. Some people use it as justification for poll taxes, literacy tests, and grandfather clauses, etc. I think we went over those in class. Okay, so the Civil Rights Amendments come about in 1865, 1868, and 1870, and they are the 13th, 14th, and 15th Amendments. The 13th Amendment specifically banned slavery in the United States. 14th Amendment was the equal protection and due process of the law to all U.S. citizens and granted citizenships to all freed slaves. Thank you. And the 15th Amendment specifically enfranchised newly freed male slaves, aka giving blacks the right to vote. One of the major things that you need to be aware of is the idea that Black Americans had to go to court to get rights. And in fact, it wasn't just Black Americans, it was actually pretty much any minority, whether it was women, Hispanics. At some point, they had to go to court to get their rights. Asian Americans as well. These rights were not just naturally granted to them, but all of these minority groups had to go to court to get those rights granted to them. Okay, so another really, really important court case that you must know for the AP exam is Brown v. Board of Education of Topeka in 1954. This found that school segregation is inherently unconstitutional because it violates the 14th Amendment's guarantee of equal protection. Justice Earl Warren was the Chief Justice at the time, and he found that to separate some school children from others solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way very unlikely ever to be undone. We conclude, unanimously, that in the field of public education, the doctrine of separate but equal has no place. So what's interesting about Brown v. Board of Education is, since it's a Supreme Court decision, you would expect it to be kind of binding and immediate application. But that actually wasn't the case. The South really went out of their way to prevent desegregation from happening. And you've studied the Little Rock Nine in your U.S. history classes, who were some of the first to cross the boundaries of desegregated schools. And then you've also, I know you've learned about Rosa Parks in 1955, which she took them to court and found the segregated bus system violated the Equal Protection Clause of the 14th Amendment. Here's a picture of the Little Rock Nine, or one of the women in the Little Rock Nine. Okay, so here's a brief multiple choice question for you. In Brown v. Board of Education of Topeka, the Supreme Court established which of the following principles? Okay, if you said A, you were wrong. If you said E, you were wrong. If you said B, you were wrong. If you said C, you were wrong. And if you said D, you were correct. The answer is D. Separation of students by race, even in equally good schools, is unconstitutional. Okay, and the Civil Rights Act of 1964 is probably the most important piece of legislation, civil rights legislation in the history of the United States. It outlawed discrimination based on race, color, religion, sex, or national origin. One thing you'll notice is that the Civil Rights Act of 1964 does include sex, so it includes gender. The Civil Rights Amendments do not. So it banned discrimination in public accommodations engaged in interstate commerce. It outlawed arbitrary discrimination in voter registration and expedited voting rights lawsuits. So it speeded up if you brought a lawsuit against somebody for violating your voter rights, it made it faster. It authorized the Department of Justice to initiate lawsuits to desegregate public facilities and schools. And this is kind of the threat. It provided for the withholding of federal funds from discriminatory state and local programs. It also prohibited discrimination in employment on grounds of race, creed, color, religion, national origin, or sex. Now, this was important because it's saying that you cannot be denied employment based on your race, creed, color, religion, national origin, or sex. Again, another key part of the law, or the Civil Rights Act, that paved the way for women's rights. Lastly, it created the EEOC, which was the Equal Employment Opportunity Commission, to monitor and enforce the bans on employment discrimination. The EEOC is still in effect today and still does the same job. Okay, so the impact of the Civil Rights Act of 1964 was absolutely huge. It was really, really, truly massive. For two major categories, employment and education. In employment, it banned racial discrimination in employment, and it opened up the door for the women's rights movements. What's interesting, I put a hyperlink here, so it banned racial discrimination in employment. What's tricky is that a recent study just came out that said that despite improving job market, blacks still face tougher prospects. This was a really interesting social science experiment in which, here's what they did. He mailed out more than 9,000 resumes in response to online job ads, and for each ad, the researchers mailed out 4 resumes with different names. Some of the names were Claire Kruger and Cody Baker, typical white names. Others were Ebony Booker and Deshaun Jefferson. These are more typically black names. And what they found is that they wanted to see how likely different resumes were to trigger a callback or a request for an interview. And it turns out that the black name applicants in our study received about 14% lower callback rate than otherwise identical white applicants. So this one was a little bit rough, but it's interesting. You can look through the study. It's posted on NPR. And it's pretty fascinating to show that although it officially banned racial discrimination in employment, blatant discrimination in employment, there's still some less visible discrimination in employment today. With regards to education, it outlined 2 different types of discrimination: de facto discrimination and de jure discrimination. De jure is a direct result of a law or official policy. De facto discrimination is discrimination that results from a practice such as housing patterns or other social or institutional non-governmental factors rather than the law. So it's a lot more subtle. Basically, it's social patterns of social racism as opposed to legal racism. Okay, so I brought up the fact to some of you in class that San Francisco has a lottery system that is meant to minimize racial and socioeconomic disparities in schools. For example, if I lived next to an elementary school, I wouldn't, and say I had an elementary aged kid, I wouldn't actually necessarily get to send my kid to that school. The reason being that San Francisco divides up kids so that the goal being that they can go to different schools that are more mixed. So you may get a lottery ticket for a school across town, and that's just where you go. You don't get to appeal. I think you get one appeal, and that's it. Name one clause and one impact of the Civil Rights Act of 1964. Write it down if you can. Here are the clauses, and here are the effects. Okay, so next we have the Voting Rights Act of 1965. The Voting Rights Act of 1965 was an act to enforce the 15th Amendment, allowing African Americans the right to vote. And you might ask, why would they need an amendment or an act to enforce an amendment? And aren't amendments legally binding in law? And you're right, but much of the South refused to honor the 15th Amendment, or found a way to follow the law in theory, but provide as many obstacles as possible to African Americans with the right to vote. So this is a really important piece of legislation. In the picture down here, you will see Martin Luther King. Okay, moving on to women's rights. I thought these two photos were fascinating. One showing that headquarters opposed to women's suffrage, and the other one, 2 women votes for women. You can see the difference in the audience. Okay, so as I'm sure you studied before, the 19th Amendment of the 1920s is when women got suffrage, or the right to vote. The 19th Amendment prohibits being denied the right to vote based on sex. It says, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have power to enforce this article by appropriate legislation." 2 organizations you need to know. NOW, NOW, the National Organization for Women. They're still very active in politics today. And then the ERA was the Equal Rights Amendment, which failed and did not pass. Opponents did not want women in the draft and appealed to traditional gender roles. Lastly, there was the Lilly Ledbetter Equal Pay Act of 2009. This is where women get are supposed to get equal pay. It came about as the result of a court case, Ledbetter v. Goodyear Tire and Rubber Company, and they found that the statute of limitations for presenting an equal pay lawsuit begins on the date that the employer makes the initial discriminatory wage decision, not at the date of the most recent paycheck. Okay, and for Hispanic Americans, Hispanic Americans are protected under the Voting Rights Act of 1965 and the Equal Protection Clause. LULAC, LULAC of 1929, is the League of United Latin American Citizens. It is currently the largest Latino group in the United States, with local councils in every single state and Puerto Rico. It is still very, very active in politics, and it's something that is gaining clout as the number of Latin American citizens grows. Hernandez v. Texas is an important court case around Hispanic Americans. The Supreme Court struck down discrimination based on ethnicity and class. Mexican Americans were entitled to a jury that included other Mexican Americans. You also should know about the National Council of La Raza, which was established in 1968, another very active organization that is discussed in your book, and MALDEF. MALDEF is the Mexican American Legal Defense and Educational Fund. They fight for more funds to schools with low-income minority populations. They fight for bilingual education programs and for equal employment for Hispanic Americans. They're all very active today. MALDEF is gaining additional political clout in recent years, so definitely something to pay attention to. You also should know about Cesar Chavez and Dolores Huerta, who worked on the United Farm Workers Union, which was a strike against farm growers.